And the million-dollar question of what comes next. As you all know, there's a lot of unfinished business to take care of. 702 of the Foreign Intelligence Surveillance Act, Amendments Act is sunsetting in December. There's much needed attempts ongoing to update the Electronic Communications Privacy Act. It's a now 2 decades old law. There's a lot of issues with respect to international cooperation on both surveillance and law enforcement access to data, including the future of, and also related, the future of Privacy Shield. And so here today we have a really incredible group of experts to discuss these issues with you. I am going to very briefly introduce them because we have a lot to cover and relatively little amount of time. So starting to my immediate left is Morgan Marquise-Boire, who's the Director of Security at First Look Media. He's a contributing writer for The Intercept. He's a senior researcher at the Citizen Lab, and he's a former long-term employee of Google, and in 2015 he was appointed a Young Global Leader by the World Economic Forum. To his left is Elizabeth Collins, who is a board member of the Privacy and Civil Liberties Board. She was formerly Assistant Attorney General for Legal Policy at the Department of Justice. And to her left is Adam Klein, who's a senior fellow at the Center of New American Security, former law clerk to Antonio Scalia, and an author along with Richard Fontaine and Michelle Flournoy of a recent and really excellent report called Surveillance Policy, a Pragmatic Agenda for 2017 and Beyond, and I encourage all of you to take a look if you haven't already. So I am going to run this as a moderated discussion rather than just having us lecture to you, and we will try to keep the conversation going. There will be time at the end for questions, so hold on to your questions, and we will make sure that we leave adequate time for all of you to ask what you're interested in. So we're going to start with the discussion of 702 surveillance. As we all know, it's about to sunset, or it will sunset this year. And so I'm going to turn to Elizabeth first and ask her to talk a little bit about her perspective, particularly as a board member who was the author of, one of the authors of the really interesting and excellent report on 702 surveillance.
Thank you, and thank you to the organizers for allowing me to participate here. Is my microphone on? Excellent. So taking a step back, I'm sure some folks in the room are familiar with 702, but maybe not everyone. So this is a FISA program, Foreign Intelligence Surveillance Act program that's supervised by the Foreign Intelligence Surveillance Court, and it authorizes content collection directed of foreign intelligence directed at non-U.S. persons reasonably believed to be outside the United States. In 2014, my how time flies, the Privacy Board, of which I am one member, undertook an extensive examination of the 702 program. We did a soup to nuts analysis in terms of the legal authority, the oversight, how the program was actually conducted, and also the value of the program. At the end of this, our board unanimously concluded that the program was statutorily authorized, that the core of the program was constitutional, and that the program was highly effective. We did note a couple of areas that, as we put it, pushed the program closer to the constitutional line in terms of Fourth Amendment reasonableness. And there were two primary issues. One, the fact that although U.S. persons cannot be targeted under the program, in fact, there will be incidental collection of U.S. person communications. So, for example, if they are on one end of a communication of an individual who is being targeted. The second, and here is where the board actually split a little bit more, was on the issue of what can you do with the information that you've collected pursuant to 702 once you have the information in government databases. And the precise area that we focused on as a board was U.S. person queries. Can you, although you cannot target a U.S. person for collection, can you nonetheless use a search term on the information you have collected that is a U.S. person identifier? For example, my phone number or my email address. And the board ultimately unanimously concluded that if you have a situation where it is the FBI in particular running a U.S. person query in a non-intelligence related case, that there should be an additional safeguard in place. 3 of us agreed it should be supervisory approval. The board split on what it should be. But at the end of the day, what we did conclude after 6 months was that this is a program that is subject to incredible levels of oversight. There have been no intentional abuse. The program is extremely valuable, and the results of our board's report unanimously would be consistent with what we would call a clean reauthorization of 702. None of the recommendations that we made would require any sort of statutory changes. So that's where the board unanimously ended up. I wrote separately on the issue of U.S. person queries to make clear my belief that the FBI, regardless of whether we are talking about individuals or agents doing intelligence cases, for lack of a better term, should be allowed to do U.S. person queries, and I feel strongly that they should be allowed to. This is a relatively non-intrusive tool, just plugging in someone's name. It is less intrusive than, for example, getting a pen register trap and trace on them or talking to their neighbors, and it often has the effect of either identifying or failing to identify connections. If there are connections, then those should be pursued. If there are not connections, then it allows the FBI to further concentrate its resources where they should be concentrated. So I was joined by Rachel Brand in our separate statement. I hope that provided the overview of what you were hoping for. Happy to add less or more.
Great, thank you. So I think Elizabeth hit on what is one of the most controversial and hotly discussed pieces with respect to 702 reform, and that's the ability of the FBI to query the database for U.S. persons. It's been called by many as a backdoor search because in order for the FBI to directly access that data, it would need a warrant based on probable cause. And as Elizabeth just explained, this information is gathered without a warrant based on probable cause. Adam, you addressed this somewhat extensively in the report you recently released, and I thought had an interesting proposal. So I was wondering if you could share your thoughts on this as well.
Sure. I'll just start. First of all, thank you for having me here. Echoing what Beth said about a clean reauthorization, that's what we recommend in our report. And I think if looking at the current political landscape, if you think that anything other than a clean or almost entirely clean reauthorization is going to happen, I think you're likely mistaken. And we think that that's what should happen. Anyone who disagrees should wrestle with the Privacy and Civil Liberties Oversight Board's assessment of the national security value of the program. That's a bipartisan board with people seriously committed to civil liberties, unanimously described the value of the program for foreign intelligence broadly, but counterterrorism specifically in fairly compelling terms. And I think that judgment had a lot of credibility with us, and I think it should with neutral observers as well. I do hope that over the course of the reauthorization process, the government will provide even more information with as much granularity as possible about the national security value of the program. And that defense should not be limited to counterterrorism alone. 702, of course, is not limited to counterterrorism alone. And frankly, there are many legitimate purposes beyond counterterrorism for our signals intelligence programs. And we actually undercut our own credibility when we focus exclusively on CT, because then when other non-CT uses are revealed, people jump on us and say, well, you said this was for counterterrorism, but here you are spying on our chancellor's cell phone or doing spying on our embassies, and we should defend all legitimate aspects of our signals intelligence efforts. On the subject of U.S. person queries, it's tempting to leap to damning them very quickly, but they have real potential value. And just on a conceptual level, to briefly explain why these can be so valuable, the 9/11 Commission found that one of the key failures in the lead up to 9/11 was the intelligence community's inability to connect the dots across the foreign domestic divide. And that's precisely what a query of this nature can potentially do. It can identify a connection between a U.S. person and a foreign intelligence target that was not previously apparent to the government. And that can be incredibly valuable, especially for counterterrorism, but also for things like counterintelligence, money laundering, and other areas where you can see troubling connections across that foreign domestic divide. So there is real potential value, and I think we all have, even civil libertarians and those of us who are concerned about civil liberties and privacy, have to wrestle with that real value and acknowledge the potential national security purposes here. At the same time, there, of course, is legitimate privacy concern. Jen alluded to that, and that can't be easily dismissed. What we did in our report was try to identify ways to potentially mitigate some of those concerns, or at least provide the public with more information about how that practice is taking place. I won't list all of the proposals that we made. We have a number of them, and I encourage you to pull up our executive summary. We have a very short list of the various transparency proposals that we recommend. But the one that Jen was referring to was the possibility that the FBI could continue to query this foreign intelligence data about Americans, but initially only receive the responsive metadata. So that's basically the to from information. Find out which foreign intelligence targets the American is communicating with. Then, once you have that metadata, if the connection that it highlights is troubling enough, which it may be in the cases that you're really concerned about, you can take the fact of that connection and the evidence of that connection to a judge and get a warrant to look at the content. Now, our proposal is fairly modest. We ask the FBI to consider this and Congress to ask them whether or not it would work. I did speak to people in the government, I won't say precisely who or what agency, and they were intrigued by the proposal and didn't reject it out of hand. So I think this is something worth looking at and worth exploring.
Yeah, Elizabeth, do you want to respond?
If I could just add, again, taking a step back, I think all of us are so engaged in the weeds on this that we sometimes forget to give a little bit of context. Part of the reason that the board came to the conclusion that there was no legislative fix necessary with respect to U.S. persons was because of the fact that there are already extensive oversight mechanisms in place specifically with respect to U.S. person queries, that the major agencies that are engaged in the 702 information already have a framework in place that recognize the potential privacy risks of this. We found the CIAs to be somewhat lacking, we found NSAs to be somewhat lacking, and we found FBIs to be charitably a little confused. So we did make recommendations as to each of them that they needed to both tighten up and clarify what analysts were allowed to do. And our goal there was twofold. One, making sure that people really stopped and thought before they took the step of putting a U.S. person query into the system. This isn't something that should happen as a matter of course. It does have privacy implications. And second, greater ability to audit. And so having a better oversight mechanism of why particular analysts were doing U.S. person queries so that you can determine whether or not there is a lack of training, whether they're overused, whether they're used for the right purpose. So that was a lot of why, and we just found the FBI's so-called minimization procedures to be unclear as to what they were doing. They did subsequently clarify their minimization procedures. The minimization procedures are the safeguards that the government presents to the FISA court that are approved by the FISA court, and the program is contingent on the approval of those minimization procedures and the government following those minimization procedures.
And just to be clear, I'm sure everyone here knows this, but the minimization procedures deal with things like retention and dissemination and a host of other things that are meant to provide additional privacy protections. Morgan, I want to give you a chance to jump in here.
Yeah, I mean, I have sort of different concerns regarding 702, which perhaps sort of, I mean, sort of both privacy concerns, but actually also sort of commercial and global. So, I mean, 702 has been a little bit of a problem for Silicon Valley technology companies, right? Like, some of you guys might be aware of the sort of safe harbor provisions and the complicated mess that was sort of created for Silicon Valley by the collections of, allowed under 702, which meant safe harbor, the CGEU decided that safe harbor no longer applied, which meant that all of a sudden, companies like Google, Amazon, and Microsoft, which significant portions of the internet globally run off, and that is commercially very lucrative for the United States, that all of a sudden the agreements they had in place allowing them to host and procure European data no longer applied. And this is kind of a mess that we are only really just fighting our way out of. And so, I mean, as my colleagues on this panel stated, it seems unlikely that 702 will sunset. But I think we need to really look carefully at sort of commercial impact on US companies of performing this type of surveillance. While a lot of the discussion in this room has sort of said that there are adequate safeguards in place and that it's all very targeted, at least the perception is, of course, that the hundreds of millions, if not billions, of records collected under this program do not qualify as targeted surveillance. In fact, the CGEU definitely thought that it qualified as mass surveillance. And for these reasons, there was no longer a safe harbor provision. And so I think that not only the sort of privacy concerns within the US, but the sort of economic impact with global business partners is something that we really need to think about with regard to 702. I would like to mention that, with regard to the sort of querying of American domestic records, I mean, a lot of American data is gathered up under the authorization of this act. Now we could kind of split hairs about the efficacy of some programs that were sort of authorized under this and sort of 215, like the Verizon metadata program, which was gathered up extensive amounts of US citizens' data, was found to be largely ineffective. It did catch a Somali cab driver moving $8,500, which one might say is substantially less than the cost of the program. But with regard to sort of internal safeguards for data, the LoveInt sort of debacle showed that there were sort of multiple NSA employees that were sorting through Americans' data, primarily spying on their girlfriends. And so I'm not sure this demonstrates sort of adequate internal privacy oversights. But I think, again, the larger picture is probably how sort of these aggressive surveillance policies affect our sort of global economic standing.
That provides a great segue to talk a little bit more about some of the international cooperation and perspective issues. And as Morgan just mentioned, Safe Harbor, which was the agreement that allowed the commercial sharing of data from companies, the transfer of data from the EU to the US that allowed it to take place. The former agreement that was in place, Safe Harbor, was struck down by a European Court of Justice case, and the case, as part of its ruling, talked about some of its concerns with respect to 702. I'm sure we may hear more from the panelists, some of what the court said was not a totally accurate characterization of what 702 does and how it operates. But as Morgan said, perceptions matter, and that was the perception of the court. In its place, we now have what's known as Privacy Shield, which is allowing these data transfers to take place. They're obviously hugely important. There has been a new lawsuit brought against Privacy Shield. So I'd like to turn it over to, I'm not sure who wants to take the question, Adam, maybe, about what you think the future of Privacy Shield is and what could be done to help protect its continued existence.
Sure. I think that Privacy Shield its continued existence, and hopefully success is a very good thing for the United States economically, for particular U.S. companies whose success we should be concerned about because they're major exporters and major innovators and major sources of U.S. influence and national power. At the same time, I don't think that the answer to that, the way to make that happen, is necessarily further unilateral concessions. Somehow, unfortunately, we seem to have gotten ourselves caught in this paradigm of unidirectional judgment, where European countries judge the United States and cast opprobrium on the United States for things on which their systems are actually far worse. Just to give one example, Germany recently passed a statute for the first time creating explicit statutory authority for their analog to Section 702. So basically, vacuuming up information off the internet about targeted foreigners. Beth doesn't like the term vacuuming up, but I'm talking about what they're doing here, Beth. About targeted foreigners as it crosses the internet pipes in Germany. And they specify how much data the BND, that's their intelligence agency, can take off these pipes and so forth. And there is a hierarchy of protection for non-Germans in the law. EU institutions, EU member states, and EU citizens. Americans are not in there anywhere. By contrast, in Presidential Policy Directive 28, which President Obama released after the Snowden revelations had roiled the waters of these issues globally, we made various commitments to protect the privacy of non-U.S. persons from all countries. For example, a German's information will age off the U.S. intelligence community servers after 5 years unless someone specifically says this is foreign intelligence information and we need to save it for this reason. So there's a clear imbalance there. And the question is, why should these countries be sitting in judgment of us and hammering our companies and placing our companies at a great disadvantage potentially and asking us to reform our surveillance programs in ways that they have declined to do themselves? And if you think that the answer is that this is perfectly fine, the question that I would ask is, why isn't Americans' privacy vis-a-vis the BND or GCHQ, the British service, any less valuable than a German's privacy or a Russian's privacy or an Iranian's privacy vis-a-vis the NSA, which of course, as we all know, hopefully, is lawyered out the wazoo and covered with compliance policies, and there's judicial review in various respects for many of our surveillance programs. So I'd ask you, why should an American receive lesser protection? I don't think they should. And so our prescription is to make certain parts of Presidential Policy Directive 28 reciprocal. We would say, if you want these protections for your people, you have to give them to our people, and credibly. So Russia, I'm sorry, but your promise to protect the privacy of Americans is not credible. And I think this would have several benefits. First of all, it would get Americans more privacy protections against foreign intelligence collection. Second of all, it would give our intelligence community more leeway to collect against the really hard and aggressive targets, Russia, China, Iran, North Korea, and so forth. And third, and this is perhaps the most important and most relevant for Privacy Shield, it would highlight to the world, but especially to Europeans, look at all these things that we have done that you have not matched. And it becomes much harder then for the Court of Justice of the European Union to say, oh, America is so terrible in doing all this mass surveillance. And that's really the challenge, is how do we get Europe to pay attention? And we think that this is one way to get them to pay attention.
So I'd just like to respond to that. First off, I am actually incredibly pro anyone getting better privacy protections, so I think that arguing for greater privacy protections from US citizens with regard to European intelligence collection is a fantastic idea. Having said that, power dynamics actually matter. So, for instance, the amount of the internet that is run on US services that passes through US controlled points, be that the continental United States, fiber owned by the US, data centers owned by US companies globally, is orders of magnitude greater than what is controlled by Germany. So in this case, like for instance, the idea that, I mean, as I mentioned before, so I believe that the last major company to build their own cloud was Twitter. And Twitter's been around for quite a long time. Substantially, most of the world actually runs off, again, Google, Amazon, and Microsoft's cloud services. These are all US companies. The amount of data that the US government can collect, because it's actually within its sphere of influence, is just, as I mentioned, far, far greater than that potentially collected by Germany. So I do see the sort of the policy point here, but I think in terms of the actual amount of intelligence, it's conceivable that the US probably has data on, I don't know, every German internet using citizen. I'm not sure if the converse is nearly true.
Jen, can I very briefly respond to that? I don't disagree with that. I mean, I think it's fair to say that there is probably a capability imbalance here. What weight you give to that depends on what perspective you take. And I think it's fair to say that you're coming at this from a neutral perspective, looking at this as a neutral international arbiter, trying to figure out what is just, equally just to all nations. Whereas I'm coming at this from a more U.S. interest-driven perspective. And those normative priors lead us in different directions, but at the same time, it's clear that this administration is going to be approaching these issues through a U.S. interest-driven perspective. And so if you're a civil libertarian, the question is, what is the best U.S. interest-driven case you can make for preserving PPD 28 in any form?
That's fair. Did my accent give it away?
Elizabeth, I don't know if you want to jump in, but in particular, I'm interested. I mean, I think it's at least possible, if not probable, that the new administration will take steps to at least rip up parts, if not all, of PPD 28. And what are the implications of that for Privacy Shield and broader?
So let me answer in two different ways. First, I forgot to give my caveat, which is I am speaking as an individual board member, not on behalf of the board. To the extent that I was explaining the board's report, that is publicly available. The other is that we have a counterterrorism mandate. We are directed to look at actions taken to protect the United States against terror. So we don't necessarily look at commercial implications. But what we did find when we looked at 702 in particular was, at best, a complete lack of understanding of what the United States government was authorized to do and what it was and was not doing. So consistent with the notion that there were commercial impacts, we looked at a couple of issues, which was, one, education about what the program allowed and what it didn't. As a part of that, we sought and received declassification of 100 different facts because we thought there was just so much confusion about the program. Second, we supported greater transparency overall, and part of that was supporting a dialogue between the United States government and various companies about what they could disclose about their efforts, about their, some call it cooperation. It's like, well, when I'm on the receiving end of a court order, I don't really call it cooperation, but it is complying with a court order, but allowing, trying to find a way that there could be greater information about what companies were and were not doing. Third, we do have an oversight system that is unique in the world. I'm part of it. There is no equivalent to the Privacy Board anywhere else in the world. And the FISC, the Foreign Intelligence Surveillance Court, is unique in the world. That said, there were serious concerns about the effectiveness of the court. Having been at the Department of Justice, having now looked at the operation of the court from an oversight perspective, I personally think that they do an incredible job. They are in no way a rubber stamp. But there wasn't a lot of information about how the FISA court did its operation. So we tried to clarify what the court did, and we did make a couple of recommendations to help increase confidence that the court was doing its job and could do its job. We were sensitive to the fact that there was not a great deal of understanding about the oversight mechanism and that the oversight mechanisms could be strengthened. And finally, to your point, the efficacy question. So our board concluded on a 3-2 actually in the report, if you look at the report. But the question, if the question is, did 215 thwart a specific plot, you're going to have a hard time finding that. If you look to whether or not 215 provided valuable information, whether it was for triage purposes, whether it was for confirmation purposes, whether it was for case building purposes, I think the answer is undoubtedly yes. But we made a recommendation to the United States government that it needed to do a better job of explaining why it maintains these programs and how are they effective. So I agree that there's not always a good dialogue about how various programs, if they are worth their weight, how are they worth their weight, and are they worth the costs in terms of privacy and civil liberties implications? And we've urged the government to undertake qualitative analyses of whether or not they should be pursuing some of these programs. On PPD 28, our board was invited to look at the implementation of PPD 28, not the underlying policy of PPD 28. We did provide a report to President Obama in late December. The board, it was a unanimous report with 4 separate recommendations about the implementation. It is classified, the report. There were 2 separate statements as well on specific issues, but we did not look at the overall policy and whether or not PPD 28 should be preserved going forward.
So I'm going to shift gears a little bit just because we do have a ton to cover, and hopefully there's some of this, we can come back to some of this in the question and answer period. But I wanted to talk a little bit about ECPA reform of the Electronic Communications Privacy Act. Again, as everyone here probably knows, the Email Privacy Act, which would have done 2 things. It would have required a warrant for all stored content, and it would have amended what's known as the no notice provision, which precludes companies from disclosing that to their customers that they've been the subject of a warrant or a subpoena or a disclosure order. It would amend that to limit those no notice orders to a time period of 180 days, but right now they can potentially be issued indefinitely. This passed the House in April unanimously. It stalled in the Senate for a number of different reasons. So I would like to turn it over, I guess, back to Adam again to talk about what you think the prospects are for ECPA reform under a Republican-controlled Congress and with the Trump administration, and what you'd like to see happen with respect to ECPA reform.
Sure. I think that it's a good thing to do, but I think the question you asked is whether I think it's likely to happen. Contrary to what our preconceptions might be here, there's not a strong partisan valence on this issue. It passed the House 419-0, and this is a substantial piece of legislation. How many substantial pieces of legislation passed the House unanimously with such broad bipartisan support from the far left to the far right, the libertarian right to their counterparts on the left? So that shows that there's incredible public consensus on this issue. So the question really, rather than why, should be why not? And there are two issues that came up in the Senate. One was this so-called electronic communications transaction records issue. These are things like what websites someone visited and various to and from information about the routing of messages over the internet. I won't get into the technical details there. There are good law enforcement arguments for why these things are useful. On the other hand, there are serious civil liberties arguments about why we should be concerned with law enforcement getting these routinely without a warrant. I think that's a debate that should happen, but it should probably be saved for another day, given the overwhelming national consensus about a warrant for email content. The second issue was the Securities and Exchange Commission wanted to keep the potential power to get email content without a warrant, just in case the subject of their investigation refuses to turn it over despite civil contempt sanctions. This is a power that the SEC is holding in reserve, but has apparently never used. I think that there's actually a decent chance that an administration with a number of ex-finance people in it will be less than sympathetic to the SEC's wishes here. So maybe that gives us a better chance than we expected of getting this passed. I think if the administration wants it to prove its critics wrong and defy expectations and build some bipartisan credibility, this is something it should look at moving.
I mean, I cannot believe that we're actually still discussing ECPA reform. This is just infinitely frustrating to me. So as some background, I worked for Google for 6 years, right? So I worked for a company that provides Gmail, which is one of the world's largest mail services. And the provisions outlined in ECPA are just so wildly antiquated and not related to reality that, I remember being frustrated about this close to 10 years ago when I started at this company and being like, I cannot believe that the provisions in the law, I can see why law enforcement would like to be able to obtain email data without a warrant. However, I would actually probably prefer that law enforcement go through my bedroom than go through my email, which I think a lot of people actually probably feel the same way. The law has been so far from reflecting the reality of the situation for so long, I said, that it is actually literally mind-boggling to me that we have actually not managed to pass anything sane on this issue. So, I live in hope, but I can't say I'm entirely optimistic about it, given how long they were sort of dragged our feet. Like, sane things have pushed forward, and then, we can't reach consensus. So, yeah, if this administration can do anything right, maybe ECPA for reform will be it. But
Can I just add that this is already something the FBI the Justice Department is adhering to because of a court ruling in the Sixth Circuit about 6 years ago.
Yeah.
And so this would not change current law enforcement investigative practice at all.
I had the same reaction when I saw ECPA reform on the list, because I worked on this at the Department of Justice from 2005 to 2008. At the time, a couple of things came up, one of which I still believe to be true. There was first an issue that, given various court orders, you had different districts across the country following different rules. That is not a sane system. That it should not depend on which judge you get as to what type of showing you need to make and what sort of process is available. The second part, and it came up both in ECPA reform and also in the FISA Amendments Act itself, is that you need to get away from statutes that are contingent on the type of technology that is in place at a given point in time. You need to move towards technology neutral legislation to the extent that you can. What is the information that is at stake? What are the privacy implications of the information at stake? Not how it's being acquired, how it's being stored. These are the types of themes that I believed then and I believe now. But I thought, well, at least I don't have to brush up on ECPA reform because the same exact issues are still in play 8 years later.
I mean, I think that it's sort of something like it's kind of, it becomes more and more pressing each year, I think, as more and more of our lives sort of become digital, right? And I think that's kind of the point. It's no longer, digital conversations are the preserve of, sort of commerce and the nerdy, right? It is just the default method of communicating. So I think that's one of the reasons why sort of every year it becomes more and more confusing and irritating that this issue hasn't been resolved.
And so obviously there are new issues that come up over time, and one of those new issues results from, as probably everyone here knows, Second Circuit ruling in beginning of the summer, in which the court in what's known as the Microsoft Ireland case ruled that the U.S. warrant authority under ECPA which is needed to access stored communications, only governs data that happens to be located within the United States. So if the U.S. is investigating a crime and the data happens to be held on servers overseas in Dublin or wherever else, under this ruling, the U.S. can't access it. They have to work through a mutual legal assistance process, which tends to take a lengthy amount of time and sometimes isn't available at all. So I'm wondering if anybody has thoughts on whether we need to think about a fix to this, and if so, what that fix would look like.
You might have some thoughts.
Right. I believe you've written on this topic if you'd like to.
I read this paper recently
Right.
by Jennifer Daskell.
It was very excellent.
And Woods, right? That was the co-author. I care about this.
I do have thoughts. I'm happy to share. Probably the question gave it away. I think it's not a sustainable solution, and we need to figure out a better answer in which U.S. law enforcement's ability to access data is not dependent on where the location of the data happens to be held. Conversely, there's a separate problem of foreign governments trying to access data that happens to be located in the United States. And because of the way ECPA is written, being required to go through a mutual legal assistance process in every instance. And that, too, I would suggest ought to change. I don't know if the panelists have more that they want to say.
I mean, I'm not sure we have great solutions to this right now, because the MLAT process is something that, again, primarily there's a lot of requests being made of US companies by foreign entities, and I have copped it in the ear from many people while speaking at international conferences who really wish that there was an easier way to get at data for the purposes of criminal investigations. Conversely, I think it's really, really hard to come up with a standard by which we decide which companies to give data to and which countries we decide, or which countries we make it easy to get data and the reasons why we give it to them. And so, for instance, I think most people would probably balk at the idea of, homosexuality is illegal in Russia, and so therefore, if Russia decides that they want to round up homosexuals, maybe we should, ask if, Amazon will give all of the user data about, people who visit these homosexual message boards. I don't think that people would be very comfortable with that at all. And I think Amazon would probably be deeply uncomfortable with this. But then deciding which countries we make it easy for and which countries we don't it seems very fraught trying to make those types of judgments. Because I think the response to countries that we say well, you don't meet our incredibly moral high bar, will say Guantanamo is still open. This is just the sort of obvious back and forth that you actually all of a sudden you're in the mire when you start trying to make these. So I don't know. Maybe you have. Do you have?
Adam, do you want to?
I don't want to ventriloquize you, so if you want to respond directly.
I think that it's worth just taking a look at legislation that the Department of Justice proposed in June as well, in which they seek to address this issue. What the legislation would essentially amend ECPA to permit the executive branch to enter into agreements with governments on a case-by-case basis. And it would require the Attorney General and Secretary of State to make a determination that the country abides by basic rule of law and human rights principles in order to be eligible for the agreements. And then on top of that, to address some of your specific concerns as well, there would be requirements as to what the specific requests could look like. So a company could only comply with the request from that government if it was targeted, if it was used for purposes of serious crime, if the request was subject to some sort of independent review, and a whole host of other protections. We can debate the specifics of the protections, but I think it's the right approach, and it begins to both facilitate cross-border access and relieve some of the pressure on the system, and hopefully do so in a way that promotes and respects the development of human rights and privacy principles. So I want to turn back to Elizabeth for a second. You talked a little bit about the importance of oversight and how from your perspective, the oversight in the United States is so much greater than in most other countries. And one huge piece of this is the board that you're part of. So I just wanted to give you a few moments to talk about what you saw as the future of the P Club going forward, and where we stand now, particularly with the board is not full at the moment, which I'm sure Elizabeth will describe.
Sure. So the Privacy Board is structured as an independent executive branch agency. It is governed by a 5-member bipartisan board. There is a full-time chairman and 4 non-full-time members. There can be no more than 3 of any given party at a particular time. The board has had a long and storied history. This is actually the 3rd iteration, and for many points in time after, this is actually the fulfillment of a 9/11 Commission recommendation from a decade ago. For many periods of time, there was no functioning board. We hit our stride, I think, in a very meaningful way over the last couple of years, and that's twofold. In our substantive work, in terms of the reports that we've issued and the advice that we have provided, because we do both oversight and we provide advice, and also in terms of starting a federal agency from scratch. And I cannot emphasize to you enough how hard that process was and how ridiculous that process was. When you have 4 part-time members trying to do national security oversight and also writing telework rules or OSHA compliance and whatever it might be, because although we are what is called a micro agency, we are subject to every one of the various generally applicable rules that the federal government imposes on its agency. So the process of agency building has been hard. It has been, however, productive, and we really hit our stride. That said, our chairman resigned last year. Given the way that our terms were staggered, we lost a member whose term expired when the last Senate adjourned. Another member resigned earlier this month. So we are currently down to 2 members, which means we are in what is called a sub-quorum situation. So actions that require the work of the chairman, which I would add is only the chairman can hire staff, one of the marvelous little twists in our statute, only the chairman can hire staff. We can't hire staff right now. We can take detailees from other agencies, which is what we did at our inception, and worked actually better than you would expect, but we can't hire new staff. Right now, we are almost fully staffed up, so it's not a dire situation, but one could imagine with attrition that it could rapidly become a dire situation. We can't do anything that requires the board to move forward. However, individual board members still retain certain obligations and authorities, and the board spent a lot of time before we lost a quorum ensuring that the agency could continue on with the work that it could do, including the agency building aspect, including additional oversight projects, and to the extent that folks in the intelligence community happen to care what I think, soliciting individual board member advice. So there are things that the board can do, but there is no question that our position is different in a sub-quorum situation.
So no conversation about surveillance can continue without also a discussion of encryption and decryption. So we're going to talk about that for a few minutes and then open it up to questions from all of you. So, I mean, this obviously came to a fore last year with the lawsuit against Apple and the eventual solution that the government was able to find a way into the phone in the San Bernardino case. So do you want to turn it over to the panel as to just your thoughts on what's the best approach going forward, what's needed, what do we think that the ultimate solution in the Apple case is the right one, that the government finds what some people call government hacking, the government finds its own way in rather than trying to compel the companies to do so when they don't wish to comply?
I mean, I was going to call this a duplicitous lawsuit by the FBI, and that the desire to force Apple to make modifications to globally produced devices which are sold to citizens all over the world, rather than unlock the phone via a commercially available solution, which they were able to purchase for not very much money. I thought was somewhat disingenuous, and the sort of they could have just unlocked the phone. So I mean, I think that it's generally right, like a bad idea. Again, like it's deeply commercially harmful, right? Because there's sort of two things going on. There's the whole slippery slope thing, right? And that if Apple is a global company that sells most popular mobile phone, then all of a sudden they have manufacturing bases in China and and so on and so forth. So that means that they can be leveraged by a variety of governments to provide backdoor access to their platform. I mean, using Apple as an example here. So going from making an incredibly secure product, they go to making a product that can be accessed by, in theory, multiple governments. But as encryption experts will actually tell you, backdooring encryption is a little bit like drilling a tiny hole into a windscreen, in that you weaken the overall protective nature of the screen so massively that, of course, what you do is you don't target the non-backdoor parts of the encryption. You just target the backdoor that you actually know is there because you've built in security weakness into your platform. And so, we have a US company that makes a really secure device, so we want them to make it less secure for the US government, which then makes it less secure for everybody, and then is going to have this slippery slope effect of having multiple governments around the world who will also demand backdoor access to Apple's platform. So, I mean, sounds like a great solution to me. Like, I hope my accent didn't obscure the sarcasm.
I'm not a defender of the backdoor solution, but on the other hand, I've spoken to federal, state, and local law enforcement. Particularly for local law enforcement, this is a real problem for them. To some extent, that might be addressed by better educating them about what alternatives to getting around encryption are available, so how they can get data stored in the cloud through lawful process and other things. But it is a real problem for them. I'm sympathetic to the law enforcement challenge here. That being said, what is the politically viable solution here? I think it's precisely what you alluded to, getting commercially available workarounds where they can be purchased, alternatively giving the FBI more resources to develop its own internal toolkit, and at the same time giving the FBI resources, and this would be a substantial task, so they'd need substantial resources, to serve as sort of a resource center for state and local law enforcement when they're confronted with these challenges. This is the path that Germany has taken. They recently created their own agency. It's supposed to get up to 400 people ultimately, I think, to help law enforcement deal with the encryption challenge without a legislated backdoor. So if this is going to be the political status quo, which I think it is, at least for the foreseeable future, the question is, how can you help law enforcement cope better with a world without backdoors?
I'll just note the board has not looked at this issue. My own view is the issue tends to underscore also the peril of policy making by unique case or policy making by specific judge, and it does seem to be an issue that cries out for a comprehensive legislative solution.
I would really hope that people legislating on this issue actually get the right amount of technical advice on this, simply because I think a lot of the rhetoric I've heard around this is really damaging. It was really interesting to me because all of a sudden it meant that encryption became a very mainstream issue. So I live on the West Coast in San Francisco, and then all of a sudden there was just a swarm of reporters from all over the country reporting on this issue, and they'd just never written about encryption before, right? And they actually had really, so I ended up running a workshop where I sort of explained the basics of this to reporters and how not to sound really, really stupid when writing about encryption. And you know, part of the thing that worried me was there was kind of a lot of very high-profile political rhetoric was like, well, I don't know about a backdoor, but we need some solution. And Silicon Valley has a lot of very smart people, so we can get them to bend the rules of math for us now, because I'm important and I don't understand math. And I was like, oh, wow, this is going to work out so well. And like in our alternative facts world, like I'm actually increasingly worried about this, where there's a like, yeah, math, I was never that big into that. Just do stuff, which will inevitably actually result in sort of weakened security of American products, which I think is a terrible idea. So this is actually something that kind of keeps me up at night, so I'm sort of worried about over the next few years. And like, I don't mind if people try to legislate it, I just hope that they actually get the right advice from people that are actually manufacturing the products, that are actually performing the research on the math that actually makes the devices secure. Otherwise, there's going to be, as I said, sort of vague orders from, there'll be policy which says that people have to comply, and then this actually trickles down to individual engineers at desks that are like, I have to do what? That's not really possible. Like, yeah, I know, just, you know, hand wave it. Which is I don't think that's what anyone actually wants.
With that, I'd like to turn it over to all of you for questions. There's someone who's, I believe, walking around with a microphone right here.
Thanks. My name's Robin Green. I'm with the Open Technology Institute. And I promise there's a question at the end of this. But I wanted to express some disappointment about some of the conversation here and representation. There are advocacy groups who have been working on every issue that was discussed on this panel, and not one of them has been represented, and we largely have serious concerns about a lot of the issues, including in particular Section 702. We have serious concerns about the scope of collection. We don't believe that the minimization procedures and the oversight are adequate. We have serious concerns about backdoor searches and the constitutionality of them, and many other issues that were talked about here. So I would have loved to have seen a representative from the dozens of organizations that have worked for over a decade on these issues represented here to talk about that. I did want to bring the conversation back a little bit to one specific issue that Adam mentioned. This is the ActorFix electronic communications transactional records. The National Security Letter Authority may be expanded if some members of Congress have its way. This is an authority that has no judicial oversight. It's just an administrative subpoena that the FBI can issue. And so I was hoping that some of the members of the panel could talk more about what the privacy implications of that would be, and a little bit more deeply about what actors entail, what kinds of information they can reveal.
So I agree with you when it comes to concerns about 702 and it being used to authorize like wide-scale upstream collection. And I think it's very difficult because there's kind of an insistence that this is, by the government, that this is used for targeted surveillance. And then of course the other argument is like, well, this is used to justify upstream bulk collection of hundreds of millions, if not billions, of data records of people. This constitutes mass surveillance. But like I do feel that this is probably. Are you guys unaware of this opinion of 702?
Completely aware of this opinion of 702. And in fact, one of the questions that the board looked at was whether this is targeted or mass or bulk surveillance, even given the various contours. And we unanimously concluded that although there is a large amount of information collected, it is targeted collection. On the upstream, we also specifically looked at the distinctions between PRISM and upstream collection and the different privacy implications of both. And for example, upstream, you can't do US person queries of upstream collection just because of the nature of the collection. Only the NSA gets access to upstream. It does not go to other agencies. So yes, we were very aware, I am very aware of the concerns. We held hearings where we did invite various open society folks to come in and talk to us and to educate us. And part of what we wanted to do was ensure that the debate had a factual framework, which is why we pushed for declassification of issues. But the conclusion of the board, bipartisan, was that it is a targeted surveillance program.
Is the logic by which you decided that the collection of billions of records counted as targeted, is that actually in the report?
Yeah, it's a selector-based collection. It is a selector
Right.
base
Well,
that has
so
also
having
that is-
written on some of those collectors, some of the selectors are things like any German who visits these selections of message boards, right? Which is like, that's incredibly broad, right? Like, I mean, sorry, I wrote an article about this, and like some of the selectors are just wildly broad. Like, they would not meet the bar for, say, legal requests if you were actually going to, like, I mean, you sort of talked about this with the cross-border data reform, right? With the, it has to be sort of, appropriately scoped. And so some of the selectors there, I was like, wow, this is amazing, right? Like, the amount of data you would collect on this, I mean, I don't know whether this is just sort of sloppy operations and that people were lazy when they wrote them, or whether or not it's deliberately like, well, we're just going to try to carve out as massive a chunk of data as we can.
Yeah, I could say that based on having actually looked at the selectors, having looked at the rules that accompany the selection and use of selectors, and also talked to the operational folks, the idea that they want to pull in more noise and less actual information that can be useful to them, I think is a misconception. There are rules that actually we talk about some of the limits on what selectors can be used. We looked at that precise issue and ultimately concluded that it is a targeted program.
Okay.
Yes, there was also a question about ECTR and about how, so the ECTR, Adam talked about this already, but ECTR would allow the government to access browsing history, which obviously can reveal an enormous amount about what one's interested in, what's potentially a whole host of things about an individual if you're collecting information about their browsing history. And the ECTR reform that the government wants, which Adam already stated, would be to permit FBI to be able to access this data pursuant to a national security letter, which doesn't require any sort of court oversight and is therefore quite controversial.
Thank you very much. I'm Mike Nelson. I do public policy for Cloudflare, which is a web security firm. We're based in San Francisco, but we have 60 people working in London, our European headquarters. So we've been paying lots of attention to the investigatory powers bill. Yeah. You guys had a great discussion on the courts and how they're influencing policy in Europe and indirectly here. Do you think there's going to be court challenges against the investigatory powers bill, and how in the heck is it going to be implemented?
Sounds like a you question.
So there already have been some challenges.
Shocked if there weren't.
Yeah, I believe that there's already one challenge that's already been launched against the investigatory powers bill.
You said successful.
So I mean, I don't know. I mean, especially, to the extent the largest, the most significant check in this regard has been the European Court of Human Rights. With Brexit, the UK is obviously not part of that system, or won't be part of that system eventually, and so I wouldn't even fathom to guess what's going to happen with respect to that bill.
Just in general, how do you compare with
I believe there was a successful challenge recently to the predecessor, which is called DRIPA, and the doctrinal implications of that decision might extend to some part of the investigatory powers bill.
Of course, the common name for this, the Snoopers Charter, right? Just 'cause, I mean, I occasionally joke with colleagues that the UK has forgotten more about surveillance than most countries will ever learn, because they're just so enthusiastic. I hope that there'll be successful challenges to it, but I mean, I'm not necessarily that optimistic when it comes to the UK courts.
I will say that there is one positive piece, from my perspective, a positive piece of this bill, which is of the UK bill, which is, despite being called the Snoopers Charter, for the first time the UK requires judicial review of requests for stored communications content and in a host of other areas as well. And it's the very first time that that's ever been required under UK law. Up to this point, these requests could be authorized by the Secretary of State on his or her own authority without having to have any sort of review by some sort of judicial body. So that, I mean, that often gets lost in the discussion of this, but I do think that's one positive aspect of the bill.
It does mean that we can continue to argue about this in court, which is, or can we not? Is this?
It's like a war. They're not open contested hearings like a U.S.
I mean,
warrant
so
application.
can it be? But it can be challenged subsequent to.
This is getting too much in the weeds and might be outside of my expertise, but I believe the information that's collected can't be used. Unlike the U.S., the information that's collected is not actually used in criminal investigations. It's then used to build a criminal investigation around, so actually the individual defendant doesn't have the same capacity to make a challenge that we do in the United States. Other questions? We've got time for maybe one last question.
Hi, my name is Claire, and I'm an undergraduate at the Catholic University of America. Elizabeth, you mentioned something about looking for privacy laws that are more technology neutral so that we don't have ECPA that's 20 years out of date. And not to get too philosophy nerd at a tech conference, but one of the things that's often seen as part of the domain of higher law or constitutional law is law that is supposed to be neutral and sort of last for 100 years, 200 years, even beyond that. Is this an area where you could see, needing constitutional definition or a constitutional amendment so that we can sort of maybe avoid the problem of looking at something 5 years later and saying, wow, we had no idea what we were doing at that point, and now this is useless?
So I think there's a couple of strands to that. And I mean, U of C grad, University of Chicago undergrad, so I love the idea of some sort of higher order principles here and philosophical approach to it. But I think what you have right now, and I think what you're actually asking about, is a constitutional framework that draws pretty clear lines right now between things like content and metadata. And there's where you see I think a gap between where technology is, where it was. And I think that the Fourth Amendment case law will continue to evolve, and it will likely continue to evolve on the criminal side as folks are facing imprisonment based on information that was collected either without a warrant. And you're starting to see this in some of the more recent cases. My point on technology neutrality is more literally about like the means of acquisition. And if you look back at FISA, it drew a distinction between whether or not it's satellite communications or cable communications. And then as telecommunication industry changed, this became a ridiculous distinction. What you were concerned about are factors like, is it happening in the United States? Is there a likelihood that there will be United States person communications? And that was irrelevant, or it was a mismatch with the way that the statute had come to apply. So I think there is going to be evolution in the case law, particularly the Fourth Amendment case law, about stored communications, third-party records, content, metadata. I think it'll be driven on the criminal side. And then getting Congress away from their love of distinctions on how information transits or is stored in 2017 as opposed to what it might be in 2017.
So with that, please join me in thanking the panelists. And enjoy your lunch.